Good afternoon and welcome to the first plenary session. The speaker for this session is not a stranger to all constitutional law students. His work, his writing has inspired several of us to study constitutional law. He has written on issues of socio-economic rights. He has taken a very important position on issues of constitutional law. He has served for many years as professor at the University of Delhi, and then also, in spite of his busy schedule, decided to take on administrative roles as well. He has been a hugely successful Vice Chancellor of the West Bengal National University of Juridical Sciences, a very popular Vice Chancellor, a rare person who can combine teaching and administration so well, continues to be an inspiration for all of us. His work on federalism and comparative constitutional law particularly is of great relevance to all students of Indian constitutional law, because he manages to combine the best of comparative perspectives with the best of the Indian constitutional ethos and Indian constitutional values. So I have great privilege in inviting Professor M.P. Singh to deliver the first plenary for this seminar on comparative constitutional perspectives. Please. So would you like to say?
Your choice. Yes, I have the choice and I'm going to explain. Thank you. This plate from here. Oh, I am too tall. Too tall. Okay. So now it is okay, or okay. Thank you, Professor Mustafa, for giving me the opportunity of being here for this occasion, and also Professor Vasanti, who insisted that I should be here on the first day, otherwise I could have come on some other day. Now, of course, I am supposed to start with the topic of comparative law, is giving you some background, some understanding what comparative constitutional law is all about. As you might be knowing, the universities which have adopted 1-year LLM course, they have introduced, because UGC requires it, a compulsory course on comparative public law. And that is how suddenly the subject has become important. Before coming to that, just some issues left to the discussion which was going on. I did not want to convert it into discussion, because you were asking questions, the judge was responding. There was not much. Just one correction, Mustafa Sahab, don't mind, that in West Bengal case, the court simply said, after examining various models of federalism, the court said that Indian model is not true to any existing scheme of federalism. It did not say that it is not a federal scheme. The only thing is that it doesn't match exactly any existing federal scheme. And the change which came in Keshwanand, that basically came because Professor Dieter Conrad whose writings influenced that decision. One of the examples he gave on the restrictions or limitations of power of amendment was that Article 1 says, India, that is Bharat, shall be a union of states. Can Parliament, in the exercise of its power under Article 368, remove this article? And I think those who would blindly have the faith in Parliament's power, unlimited power to amend the Constitution, would say yes, it can. But if it removes, then the entire face of the Constitution or of the country changes. There was an understanding that the country will be a union of states, and now there are no states. So what is this country now? Which is contrary to the entire understanding on which the Constitution was made. And that is how I think that was one influence by which it became necessary to say that whatever the kind of a scheme of federalism, India has to remain a union of states. Somebody asked a question regarding Article 3. Yes, Article 3 is peculiar, but again, closely you have to read the history of the making of the Constitution. Actually, states were not well defined at that time when the Constitution was made. And there were lots of controversies as to how to divide states or make out the states in the country. Now, if the Constitution makers were engaged in that exercise, perhaps the Constitution would have not been made by November 1949. It would have taken perhaps many more years because there were controversial issues involved in it. And therefore they designed Article 3 and 4 in the manner in which they are, that entrust Parliament for drawing the scheme of the making of the states, and it is for that reason that the Reorganization Act of 1958 could easily reorganize the states. You may say that the power has been used or misused, but that's another question. By and large, however, the exercise has been done on the suggestion or on the request or on the agitation of the states and not started by the center. So that is also another point which has to be kept in mind. The other thing which Justice Reddy said regarding the statement or observation which was made in Dhillon's case, that if the validity of an act of parliament is challenged, the only question to be asked is the subject matter of the law included in the state list? And if the answer is a no, then there is nothing more to be asked. The law of parliament is constitutional. It was basically on distribution of legislative power. Does not mean that parliament law are free from the obligation of fundamental rights or other restrictions on the laws of parliament. Soon after that, actually, I wrote a paper in which, among other things, I said this statement is wrong because there are several articles in the Constitution which independently give power to either parliament or to state legislatures. but particularly to state legislatures, which was important aspect. And those articles, the subject matter of those articles is not covered by any of the lists. It can't be read in residuary power because it is specifically mentioned in one of the articles of the Constitution. And therefore this statement is little too wide. I am not saying that that statement has been changed, but my objection or my suggestion has been fortified by the amendments for GST which has been made and by Article 246A. 246A gives an independent power to the states to make law relating to GST along with Parliament, and no amendment has been made in any list. That is, GST has not been included in the concurrent list. So, nor it has been included in the union or state list. It is just mentioned in Article 246A that the power to make law relating to GST. So again, it is not that everything relating to legislative powers is covered by three lists read with Article 246. There is something beyond that also, and therefore one has to read the Constitution carefully. In line with Sirvai, Professor Tripathi, I have been holding always the view that Article 301 is not a limitation or restriction on the power of taxation, except to the extent whatever is mentioned in Article 304A. The Supreme Court has decided only on 11th of November that is the correct position. They have overruled all the earlier decisions which said anything to the contrary or different. Even automobile case which propounded the thesis of compulsory taxes, that has also been overruled. That taxes are taxes. This is what Tripathi said, that tax is a tax, it cannot be compensatory. You cannot say that income tax is being imposed on you only to that extent to which you are being compensated by the state. You have to pay the tax irrespective of whether anything is spent on you or it is spent on someone else. So tax is a tax. If the power to tax is given to legislature, that power cannot be controlled by some idea of compensatory tax. The tax will remain a tax. Otherwise, the difference between the fee and the tax actually is removed. Sorry for these incidental remarks because they were extension of the previous lectures. Let us come now to comparative law. Yeah, there are some autobiographical developments with respect to that, and therefore they are also relevant for the purpose of how the study started. You know that maybe too young to know, but Professor Mustafa would know very well that towards the end of 60s, some changes were made in the law courses. Actually, middle of 60s changes were by this Gajendra Gadkar committee, which actually introduced a 3-year law course after graduation. It suggested some of the changes, and also in the courses. And there was some emphasis on comparative law also, that comparative law should be taught as a subject. As required by UGC and then later on also perhaps by the Bar Council, all universities started teaching this comparative law because it was a compulsory course. But most of the universities made it part of jurisprudence course, that jurisprudence and comparative law. Now, of course, there is a relation of jurisprudence with every course in law. Therefore, you can associate any course with jurisprudence. You can say jurisprudence and constitution, jurisprudence and anything. But this connecting comparative law with jurisprudence resulted in non-teaching of comparative law. Nobody taught comparative law. I don't know whether anybody taught you comparative law with jurisprudence or even otherwise. I found, however, that Delhi University had a separate course when I came to Delhi University in 1970, that it had a separate course on comparative law. And somebody was teaching it. I did not want to disturb it, and I also myself did not have much idea as to what comparative law is all about. But at the same time, if I think with that all of you would agree that we start our studies with comparative law in the sense that all our courses, and particularly so far as constitutional law is concerned, that starts with some reference to Dicey, it starts with some reference to US Constitution, it starts with some reference to other constitutions, now even to European constitutions like German Constitution. Justice Reddy also mentioned German Constitution. And that way, I had also studied as a student of LLM, the Swiss and the US constitutions as part of my study. And in the subject of federal constitutions, I also studied Canada and Australia. And that way you can say that comparative constitutions were being taught in some form or the other at that time. But whether it was comparative constitutionalism in the sense in which the discipline was expected to be taught either by the Gajendra Gadkar committee or as a separate discipline, that was another matter, because there is a theory of comparative law, there is something behind comparative law, and therefore the question is that how to develop that course independently. And in spite of these backgrounds, however, so far as I am concerned, when the time came that that professor who used to teach that course retired, and that course actually being a optional course was stopped, I could also not opt for it because I was engaged with other courses. But incidentally, I happened to know Dieter Conrad, again, whose name we have mentioned. Dieter Conrad came to Delhi University, and his assignment required him to associate with teaching in Delhi University. Professor D.K. Singh, who was the dean at that time, he asked Dieter Conrad what courses he would like to take up independently or with any other colleague. Dieter did not want to take the full responsibility of running the course, but he said he would like to associate with any course in public law, which if anybody is teaching. We did not know even very clearly as to what the distinction between public law and private law is. But of course, the idea was that courses like constitutional law or administrative law, they are public law courses. So he was associated with me. I was teaching administrative law to LLM class. So it was a small class. Dieter Conrad would come occasionally in the class, would from time to time make some comment with respect to the position in his country, but he did not speak too much for the simple reason he thought that it would be just disturbance to the class, because class is attuned to studying or knowing about what is the Indian position, while the German position on an issue may be quite different. Dieter was almost for entire academic year, went back. After that, I incidentally published an article on the requirement of reasons for administrative decisions, which was published in the Journal of Indian Law Institute. I sent a reprint to Dieter Conrad in Germany. In response, he wrote back that what you have said or tried to say, in Germany it is written into their law, in their legislation. Incidentally, I, in response, by way of courtesy, I wrote back that I wish I had known something about German law. He immediately wrote back, if you are interested in knowing German law, you may be invited to Germany, but the condition is that you will have to learn German. I was at that time nearly 38, 39 years old, already a senior associate professor or reader in Delhi University. Because from my later experience, I could never encourage any other colleague for the simple reason that nobody wants to study German language. I immediately told him that, okay, I'll learn German language also. It looked like English in reading, but it was so different, I never realized at that time how difficult it would be to learn that language and to know about the legal language particularly. And so I accepted. I was given a prestigious fellowship there. I started studying first language and then law. And I chose administrative law as my subject of study. And though, of course, it was a very difficult process, but it is in that process that I prepared my manuscript on German administrative law in common law perspective, which was subsequently published from Springer Publishers. Already second edition, and now it's going to be in the third edition. Now, from there, immediately after my return, I asked the dean, if nobody is teaching comparative law, I would like to teach comparative law. Because now I thought that I have some idea what comparative law is all about. And I can make some serious comparison between Indian law and European law, and particularly German law. So I announced to the students, to begin with, there is not much enthusiasm among the students, particularly those who came, like I think many of you, they were not so keen about studying public law. And my condition was that I will not be able to teach private law parts of comparative law. I will be able to teach only public law parts of the comparative law. Not many students were interested, but slowly as the course reports went around, the class started growing and it became quite a popular course. In that, during that course, of course, many of the students, they came and they still come and say, "Sir, we remember you for that class." Now, it is this way, therefore, so far as my introduction to comparative law is concerned, and since then that study is going on. When this comparative public law course was introduced in 1 year LLM course, and the law schools started teaching that course, Professor M.P Singh asked me whether I could help in teaching this course. I said, okay, I can. At that time I was at Delhi Judicial Academy. I said, okay, I can come once or twice, provided some of your regular teacher is there for teaching the course. He said someone would be there, but primarily it will be your responsibility to run the course. I said, okay, I'll see in what way. Initially I thought I am invited only to advise, but when he asked that I should actually monitor the course, then I had to think seriously. And while we were formulating the course, this occurred to me that the best idea to teach comparative public law would be that I give some introduction with respect to comparative public law. But if we have to teach comparative public law, which means comparative constitutions particularly, not everything relating to comparative public law, then the best thing would be that we invite people from those countries, because we have to compare Indian constitution, Indian constitutional law with other countries. We have been comparing with the United States or England or Australia or Canada, which of course may not be in many ways similar to our constitution, nor the societies are similar. Moreover, those constitutions are all much before the Second World War period. Second World War actually brought a big change in the understanding and thinking of the constitutions and constitutionalism. And for that reason, a great divide was created between the constitutions which were made earlier and the constitutions which have been made since then. So I thought, let us invite people from countries where constitutions have been made after 1950 or after Second World War. And of course, Europe fell in that category. Most of the constitutions in Europe were made after that, and prominently German constitution for me was made in the same year in which our constitution was made, 1949. So I thought that let us have someone from Germany or from Europe to teach about the European law. Then I found that something different from Indian constitution and a further step forward has been taken by South African constitution. The step forward in the South African constitution was and is that the difference which our constitution made between directive principles and fundamental rights, that constitution abolishes that distinction. That is, although initially in our constitution also directive principles and fundamental rights were together, but then they were separated, and the directive principles were made unenforceable in the courts, while the fundamental rights have been made enforceable in the courts. This position, however, was changed or has been changed in the Constitution of South Africa. So let us also invite someone from South Africa. And then the rights, for example, of course, social rights, our Constitution transferred them to directive principles of state policy basically, although some of them are in the fundamental rights also. But these social rights in South African Constitution are part of the fundamental rights enforceable by the courts. So it was a remarkable development. But most of the European Constitution also do not specify social rights as part of the fundamental rights in their constitutions, including the Constitution of Germany. But the Constitution of Germany says that Germany is a social state. And social state requires that the state must take care of its citizens and must provide to them what is necessary for their dignified living. And therefore, somehow the principle of social rights as fundamental rights or a fundamental obligation upon the state has been brought into that constitution. At the same time, in Europe, a process was going on enacting the social rights as part of the European scheme of the rights. And finally, now in Lisbon Treaty, they have actually put all the rights together, both civil and political as well as social rights. And you will perhaps not believe the way in India we are privatizing education. In Europe, anybody has a fundamental right to education up to any level, free of cost. You can even do your PhD or higher degree free of cost in European universities. We consider America our ideal. We don't want to learn from other countries which may not be as rich as United States is, but which are much more just and fair than the United States is. And therefore, we have to look to other constitutions also, what is happening in those constitutions. So we thought it necessary that somebody should teach the European position also. And a professor from Greece, I heard him once speaking on that issue, and I thought he would be the most competent person. I made the proposal to Ranveer Singh that this is what I am planning. And he said, yes, it's a very good idea, you go ahead. So, challenge for you, because it involves expenses. We had to pay for their travel. We had also provide accommodation to them and some token honorarium also. But the program has been going on since then. For the first 2 years, we did it that way. But then we thought that let us now concentrate more on South Asia. Now the question that why, after having such a broad study of constitutions from all over the world, suddenly we have decided to concentrate on South Asia. This has nothing to do with the book which Khilnani, Arun, and who is that third person? Vikram. These people have written, or recently, much later, Tushnet and our Madhav Khosla have written, we decided, independent of it and before that. And the reason was that we should understand, and perhaps that would help us in understanding, and will help in realizing our Indian scholars that why it is that in India the constitution is and democracy, constitutional democracy, to some extent constitutionalism by and large, is working and is not working in its neighboring countries with similar demography, similar society, similar conditions. Why is it that it is not working in these countries and it is working in India? It's not that it was in any way to denigrate those countries or to show that we are superior to them in any way, but to caution our students and scholars who are studying that if you do or you go for the kind of things which are happening in those countries, India can also be like them. You cannot have constitution, you cannot have constitutional government, you cannot have democracy. If it is working here, it is working because we have been different in some ways. And if those differences are actually not sustained and efforts are not made to sustain them, Indian constitutionalism, Indian democracy would also collapse. And therefore, let us study that. We invited lawyers from Nepal to teach about Nepalese constitution. We also invited from Bhutan, somebody did his PhD on Bhutanese constitution from this university. He also came. But we invited the former Chief Justice of Bhutan, who drafted their constitution, to speak on that constitution. We could not get, unfortunately, anyone from Pakistan because of visa problems and all that. But we got someone from Bangladesh. We got, without much difficulty, from Sri Lanka. And in this way, these countries of South Asia were covered. And in course of time, we have realized that this has been beneficial both for us as well as for those scholars who are coming from those countries. We also realized that although Pakistan we could not invite, but Pakistan is comparatively, if you read their judgments, quite good judgments of the courts, quite strong stand, but somehow courts alone cannot guarantee constitutionalism, nor sustain the constitutions. There have to be many forces, several forces that have to protect it. And that is again one understanding which one has to have, that don't rely too much on courts. Don't think that the courts are our saviors. There are people who are our saviors and not the courts. I think Grenville Austin is not exaggerating when in his 65 book and again in 1999 book repeated that all credit goes to the people of India. So it's not actually one institution, either courts or parliament or the leaders like Nehru or some others, but it's actually the entire population of this country to which the credit goes. And therefore, everyone, every person has to be enlightened about how constitutionalism is ensured in any country. If it works without a written constitution in United Kingdom, that is in England, it works because every British is aware what his or her constitution requires, what are the limitations of the government and what are the limitations of the individual, and what one can do, what one cannot do. And they honor them irrespective of the fact that there is no written constitution. Parliament doesn't do anything it likes to do. There are implied limitations which Parliament always observes. And similarly the courts also do not go beyond a point, though of course, like for example the present judgment on Brexit, that shows that courts perform their function, but in a framework which is well recognized in England, that something which has to be done by Parliament cannot be done in the exercise of prerogative power. There is no prerogative left with the Queen or with the people to decide by referendum whether something which was done previously by Parliament can be undone by the people the way they have done it. So, of course, the case has to go to the higher court, but hopefully, let us hope in what way it decides. There is a possibility that the decision will be upheld, the lower court decision. Now, this is therefore the study of comparative law actually is relevant from this point of view, that we do not study comparative constitutional law or comparative law as such merely with a view to know something about somebody's constitution or somebody's laws, but with a wider scheme. And that wider scheme has to be, of course, you may say, as a student for PhD or some higher studies, that you have to pick up some specific point for the purpose of comparison. You cannot compare everything, but an awareness of why comparison is done, that is important, and comparisons are done with a view to actually gain something, with a view not just solve one small problem as to how the American courts have decided on this issue or the British courts have decided on this issue, but in general, overall, that how the constitutions or systems function. Now it is this aspect, therefore, which I said that some autobiographical background I should give, that in what way I have understood the comparative constitutional law and have become part of it. If there are any questions up to now, although of course I have not yet taught law, I have simply talked about the history, but if there are any questions you would like to be clear about, please feel free to ask. Yes, please.
So, good morning, sir. Myself, Mustafa, working as a sir at SRM School of Law. So, you have said that court alone will not be a guarantee for constitutionalism.
Yes.
But I think that government doesn't have that self-imposed limitations. Constitutionalism means it's a limitation upon the government. Fundamental rights provides that limitation, but if citizens are aggrieved and the state encroaches upon their rights, the only remedy is left with the courts. So courts can effectively play a role as a guarantee for the constitutionalism. How can you say that court alone cannot? Because the government's executive legislature is not playing that part as a limited government.
Yeah. There is, when the court decides something, there is an understanding that against whom it is deciding, they will honor its decision. That when the government gives a decision against the central government, there is an understanding that central government will respect that decision. On what basis that understanding comes to the court? Court will never decide an issue when it knows very clearly. You ADM Jabalpur case, you know. A court did not give any relief to us when it knew that the government is not going to honor their decision. So courts actually give decisions only when there is a support. And the support comes from the people through their government, through their institutions. It is not that everyone, you and I, are raising flags or slogans for the court. It is rather an understanding that the government will honor the decision of the court, and the court also knows whether our decision will be honored or will not be honored. And for that reason, therefore, people's support for the court is actually crucial, that whether people are behind the kind of decision which is going to make, which it is going to make, and therefore that again is important. The way, for example, the State of West Bengal case was decided in 1965, perhaps if it were not decided the same way, I think the constitution would have been amended. That was the position of Parliament at that time, because they wanted to, the central government wanted to actually nationalize as much of state resources as possible, and therefore coal mines in the state of West Bengal were taken under that understanding and under that resolution. So all these things the courts have to take into account. Courts are not actually acting in vacuum. This is one understanding. Courts, when the situation is such that courts knows or doesn't know, then it may be a different thing. But this is important, that there must be support of the people behind the court. And so that is very crucial. Where people don't support the court, court decision will not be honored, will not have much effect. Yes, please.
Good afternoon, sir. My name is Mahamaya Chatterjee. I am a student in School of Law, Christ University. So primarily you stated that in a lot of circumstances the court believes that people should honor their decision, which is absolutely right. But sir, imagine a circumstance in the recent Kaveri dispute where the state legislative assembly has passed several resolutions in contempt of the court order, of the Supreme Court's order. But in a circumstance when a Supreme Court's order itself is not respected and revered, and the people themselves do not support a circumstance like that, then what is the recourse which the court and the highest court of the land can take? Because this has been happening repeatedly.
Of course, you may say that parties to a decision are under an obligation to honor the decision of the court, but there is also an obligation on the central government to ensure that the decisions of the Supreme Court are honored. And even when your question, even with respect to, for example, Punjab issue, the court has given decision and the Shiromani Akali Dal is openly saying we will not honor this decision. But of course that is not a decision, this is an opinion which the court has given. The opinions are supposed to be binding because the court always takes an understanding from the Attorney General that we will give the opinion only if you respect it, otherwise we will not give. So it means that the central government has given an understanding or undertaking. Now this happens, but even those states which are not honoring, their lawyers actually go with an application to the Supreme Court to continue with that issue. It means it is, or they go in appeal. It is not that they just sit down and say to the Supreme Court, we will not honor, we don't care for your decision. If that happens, I think the court will have to direct the President of India or through him the Prime Minister to take appropriate action. And of course that again would require reading of the mind of the people, how much support is there for that. So courts also do not hurry up the issue, but at the same time that understanding goes, the lawyers at least take the stand of the states that let us file a review petition, let us file a curative petition and like that. So something goes on, and that way you can justify that they have not actually disrespected the decision of the court or violated the decision of the court. Yes, please.
Sir, this is Prabhakaran. Sir, talking about the comparative law and migration of ideas, how can there be globalization of law? And
how can that be?
How can a globalization of law can happen? If there is going to be a cultural specificity, a separate legal system for everybody, how can the Supreme Court or other courts can refer foreign decision? How can the globalization of law can happen?
Yeah. Now when we are talking of globalization, are we talking of globalization in every respect? Basically globalization is about commerce. It's not about everything. And globalization of commerce is comparatively easier because these are the matters between private persons. Whether these are multinationals or other bodies, governments also may be party to it in the sense that they have to support their companies or corporations or multinationals, but their involvement is indirect. Globalization is not of constitutional law, globalization is not of public law matters. Globalization is basically of private law matters where private parties are involved. So, Professor Mustafa has already expressed his doubts. Now whether Trump having come there, whether even in private law globalization would be possible.
So, excuse me, sir, I have another doubt.
Right.
So you mentioned how you learn.
Yes, I think let us respect. Yeah, okay. You can reserve it and ask later. Don't forget it, note it down. Now, coming to some details of comparative public law or comparative constitutional law, some of the issues with respect to the subject. Yeah, just incidentally, 2 more points means, of course, I continue to teach that subject in NUJS also. We have even now in this National Law University in Delhi, where I was asked to be visiting for some time, we have opened a center for comparative law, and under that center we have started a yearbook of comparative law. The first edition of that yearbook would be appearing sometime early next year. Already the manuscript is with OUP. They have agreed to publish it. Then we have also undertaken a project on understanding or exploring the nature of the Indian legal system. And that is also being done in a comparative perspective. That is, we normally assume that the Indian legal system is common law system. Time and again we are taught that we are a common law country, our legal system is a common law system. I entertain some doubts about it, and therefore we thought that let us examine it, and we are examining it with some support from Germany, in the sense that some of the German scholars are also participating in the project and also giving us some financial support for running the project. It is not that I am acting on their behalf. I started it, or we started it, and I want to be clear about the nature of the Indian legal system, the difference between the state legal system and non-state legal system, how much we are governed by non-state legal system, including our personal laws, and laws of many communities in many matters on a research at a very small scale. We found that even in Delhi, there are several communities which never avail of the state legal system, who never go to courts or to police. Even in cases of rape, assault, divorce, other things, they just settle among themselves all these issues. I don't know about murders, but if the police doesn't come to know even murders, perhaps they will not report them to police. To that extent, I think, therefore, it is necessary to know as to how far the so-called common law system or state legal system is operating, along with a non-legal system or a different kind. You can't call it non-legal, it is only non-state legal system according to which people are operating. And therefore, that is also one of the aspects which we require to understand. Now, coming to specifically to the study of comparative law, and particularly comparative public law. Just as we have started the course on comparative public law recently, while on comparative law we had started much earlier, as I have told you. Similarly, I think to some extent there is an impression, which impression to some extent may be correct but can be contradicted, that comparative law studies in recent times, starting in the 19th century, rather late 19th century, to early part of 20th century was dominated by private comparative law. That is, in the area of contracts, transactions relating to individuals, even matters relating to what is called as private international law, which may include matters relating to marriage, divorce, etc. also. That is, these were the issues which were basically being taught as and which were being emphasized as the study of comparative law. So, the Paris Conference on Comparative Law, which was held in 1900, that primarily and basically among the European countries related to private matters, not public law matters, private matters where the private parties were involved in legal transactions. And this was happening because those countries are contiguous countries and they became all separate nations. At that time it became necessary that the people of Germany who are entering into a contract with a person in France must be able to understand what is the nature of the law relating to contract, for example, in France, and therefore, or vice versa. And in some other countries, neighboring countries, and for that reason it became necessary that, and people were migrating also from one state to another, and therefore it was necessary that number of laws which affect these private relationships, how should they be governed, they should, how can they successfully operate in these areas. Therefore it is necessary that they should know about each other's law and also learn from them. That if we find that if Germany finds that French law is superior in matters of contract or matters of tort to German law, why should German law be not changed in line with the French law or vice versa? So these were some of the ideas because of which the study in comparative law was started. So Guttridge and others who wrote during the beginning of this century, they were primarily emphasizing on private law, including private international law. There was no discussion of constitutional law or of administrative law or environmental law or any other law which could be included in the area of public law. And therefore, so far as the study of public law is concerned, comparative public law is concerned, in recent times it can be traced back only to 50s onwards, 1950s onwards. And perhaps one of the important studies in that regard is Professor P.K. Tripathi's article on the relating to the following of precedents, foreign precedents in India or in other different countries. And that article was published in 1957 in the Columbia Law Review. Professor Tripathi, as you might be knowing, was a professor, also dean head at Delhi University for many years. It is he who actually, so his writing is considered to be one of the first writings on the this judicial transfers, that is the cases moving from one country to another, and in that way to understand that how far it is important to know the law of other countries, how far it can be relevant. And Tripathi basically showed that initially actually we were following mostly the precedents from England, But after the Constitution came into operation, quite a bit of, Justice Reddy also mentioned, quite a bit of US constitutional cases, because it was the US Constitution, but also Canadian constitutional cases, Australian constitutional cases, they were also used by our courts for the purpose of deciding issues. And this is what the point which Professor Tripathi mentioned. For a long time, actually, the discussion on comparative public law continued on the basis of how far courts are relying upon the decisions of other courts in constitutional law matters, and that is how the subject started developing. But not only later on, Mark Tushnet and others, they expanded the area, that it is not merely the following of the cases, but it is also the model of the constitutions which is being followed. That many constitutions after the Second World War have been modeled on the constitution of Germany, particularly with respect to the power of judicial review. That is, instead of giving power of judicial review to a general court like the Supreme Court of India or the Supreme Court of United States, the power has been given to specialized courts which are only for the purpose of deciding constitutional disputes and no other disputes. And this model has been followed in number of other constitutions which are being made all over the world, including the Constitution of South Africa, which we have made. And so from that time onwards, we find that more and more constitutions, in the area of constitutional law, that comparative studies are developing. And it is in that context that finally these two books on South Asia also have appeared, about which we have just mentioned. But then if we analyze seriously, we will find that it is historically, it may not be fully correct that these developments have taken place only now. And this is important to understand for the reason that don't think that it is a new invention or a new discovery. Rather, people have been actually comparing themselves from very early times, that they have been looking to others and see if they are doing in some aspect of life better than them, to try to follow, try to understand and to try to follow. That has happened in the area of law also. Aristotle, when he actually wrote about his politics and constitutions, he collected information on 300 or more than 300 constitutions that existed in different democratic city-states in Greece or around that. And it is on the basis of that that he came to the conclusion that among the several forms of government, including democracy, the best form of government is constitutional democracy. That it's an old principle. It is not that today we say that the constitutional democracy is the best democracy, or today we say we are democracy, but we are not simply democracy, we are a constitutional democracy. But Aristotle had said it in 300 BC or before, that constitutional democracy is the best government which a country could have. And so it is, these ideas actually have existed from very early times. You can find subsequently, and this Professor Watson actually has found more precedents where similar studies have been made. Some people have not agreed with him, that's another matter, but the fact is that people have been trying to know about how others are governing themselves and whether there is something for us to understand from them. And it is in that context that now more scientific writings like this Ren Hirschel's Comparative Matters, that book which is referred, and some of the papers have been given to you in your materials which have been supplied from that book, that Ren Hirschel actually gives further analysis and in what way actually the comparative law studies must be done. And he is saying, rejecting many of the earlier notions or understandings with respect to it, that we have not to confine to any particular point or particular case study, but we have to understand the systems widely. And this actually has to go on as far as possible, systematically. Not only study of law, but even study of other aspects of life of those countries and other disciplines also. That you cannot exclude constitutional law, as we just tried to emphasize, from politics of the country. And therefore, it is important that we also involve political scientists in the understanding of law. And you cannot understand that why, even in Delhi, some of the people are not being governed by state law. For that, you have to have some idea of anthropological studies, or anthropology, or sociology, or history. There may be something that has kept them away from the state legal system, why they have not become part of it. And therefore it is necessary that the wider area has to be covered so far as the study of comparative law is concerned. One of the studies that, Frankenberg, this IKEA theory, IKEA, I think you know that it is a chain of, a warehouse, not a warehouse, you can call it mall or anything, that which sells everything from every part of the world, and so from furniture to clothes and other things. They collect things from different parts of the world and sell them all over the world. Now, it is in the same way that we can collect ideas from all parts of the world and either mix them with the rest of the ideas in such a manner that nobody knows exactly from where these ideas were taken, what is the place of origin, but they have become part of IKEA, that is that mall or that house which sells these things. And therefore you say, I have bought it from IKEA, that without knowing whether it is made in USA or China or Germany or somewhere else, but it has been bought from there. So similarly, so far as comparative law is concerned, it is not necessary that all the time you have to tell that this idea we have bought from there, this idea we have bought from there. Rather, merge them into your legal system in such a manner that it becomes yours. And the difference which may have been at some point of time, that difference is not noticed anymore. And so even if some precedents were looked up by the court, for example in Gopalan's case, it is not that exactly those precedents were followed. They may have been mentioned merely to distinguish the position in the American Constitution or some other constitution. And it is this way, therefore, the study has to proceed, that you have to be little bit more scientific in the study of comparative law. But for being scientific, it is not necessary that you should be copying only the way others are doing it. You can develop your own ways of doing comparative law, comparative public law also, and it is that which can bring some novelty into the system of comparative law. I think I need not go into all the details and mention specifically all the points which either Van Herschel or Frankenberg or Watson or others, Legrand and others, they have given with respect to it. You can read them as well as I can, but if there are any questions on those issues which have been raised by them, I'll be very happy to respond. So please feel free to ask any questions with respect to how to do comparative law and in what manner, particularly in public law area.
Good afternoon, sir. So my question is regarding the usage of comparative public law. Does it work in case of there is a vacuum in our public law system, or whenever the necessity arises, or it is a continuing process where the good things are being adopted or merged into our public legal system, sir?
At least theory has to be developed. What is the method and what can be borrowed and what cannot be borrowed. And it is for this reason, therefore, number of factors have to be taken into account. The politics of a country may be very different from the politics of another country, and therefore blindly you cannot follow exactly what the courts in that country have said if your politics is also not similar to that country. But it's not only politics, other factors also. Social setup, for example. Now, the issues relating to equality, for example, which arise in our country because of caste system, particularly, apart from religion and other things, they don't arise in other countries. And, or if they arise only in our neighboring countries. And therefore, the answers have to be found out in reference to that. Now, for example, even caste system, how we have dealt with it may give some guidance to our neighboring countries, which also have the same system, that how have we dealt with it. Particularly Nepal, there are some representatives of Nepal here, please don't mind, I have been going to Nepal for quite some time, and students from Nepal have been coming for LLM, PhD from very early times in Delhi University. And every student who came from there was either a Brahmin or a Kshatri. And whenever I went to Nepal and met people, whether they were running a NGO or they were in any government job, or international bodies, everybody is a Brahmin or a Kshatriya. I never met anyone who is out of these two categories in any position. Maybe that they may be on some very low position somewhere, but nowhere. Now, we used to invite for our course on comparative law at NLU Delhi, these students, my former students who teach at Kathmandu University or Tribhuvan University, and they will say everything about the problems in Nepal, but they will never mention this fact that the inequality and the kind of inequality they are perpetuating, that is one of the reasons for all the troubles that the constitutions don't work or don't function. I read this time in that Tushnet and Madhav Khosla's book from two Nepalis who are working abroad, both political science professors, not of law. And I found that they were very balanced, critical of things in Nepal, which go against the principle of equality and which lead to all the problems that exist with respect to constitutionalism in that country and instability. And therefore I decided to invite one of them. And so one of them is now in NLU Delhi at the moment. We had one class with him. And I had to remark at several places that no one from Nepal who used to come to talk about Nepalese constitution ever mentioned these facts which you are telling. Even we provoked them to say something, but they will never say. Now the reason may be that they have become so used to it that just as many people in India also have become so used to certain kinds of discriminations that they can never think of that it is a discrimination. They think that it is a normal thing. This is how my grandfather did or great-grandfather did, my father did, and therefore when the neighbors do, so what is there unnatural or unjust or unfair in it? And therefore what is required, that you have to also see that what is wrong with the society. So it's not purely reading of law, provisions of the constitution, but you have to also know about other things, that the countries from where we want to copy, what are their conditions, in what way and to what extent therefore we can borrow from them. We cannot blindly borrow. Perhaps even the German jurisprudence that the social state principle means that everyone has to be provided so much by the state that he can or she can live a dignified life. We cannot actually under our principle of socialist state in the preamble or even social justice, we may not be able to entirely implement it at this moment. We can argue that why should we not follow a similar principle, but whether the court can command the way the German constitutional court commands, if our court start doing that, it may be difficult for the government to implement it. That's why even the right to food petition has been going on for quarter century, and still it is going on in the Supreme Court. because continuous negotiations between the court's understanding, parties' understanding, and the situation on the ground, they are being discussed continuously, and of course solutions are being found, but the solution cannot be immediately this kind of decision. So therefore you have to have a wider perspective, just not a court decision, just not a provision of a statute, that would not function. Yes, please. Somebody here. Yes. Yeah, remain seated. Why need you?
Good afternoon, sir. This is Nikesh Kumar Lamsar from Kathmandu School of Law.
Perhaps it is not working, or working? Oh, working. Okay. So
This
please.
is Nikesh Kumar Lamsar from Kathmandu School of Law.
Yeah.
I agree to the point you mentioned about Nepal and its...
Yes, it's working now.
the caste problem is blended with the class problem also.
Yes.
That's the additional information on what you say. And now moving to my question. Can the study of comparative laws be seen from the perspectives of development of law versus manufacturing of laws? And a corollary question to this is, creating high legal standards with lower ability of implementation can create more public frustration leading to the dysfunctioning of laws or legal system. How can this be balanced?
No, this first part I understood, but the second one I did not understand properly.
Let me repeat it, sir. Creating high legal standards that can be obtained through comparative law
Yes.
with lower ability of implementation
Yeah.
can create more public frustration leading to the dysfunctioning of legal system.
Right.
So how these things can be balanced?
I know that is what has to be, therefore, one of the questions relating to separating the directive principles from the fundamental rights in the Constitution of India was this, that in case what is given in the directive principles, the government fails to fulfill, that is, one goes to the court to enforce them, and the government fails to do what the directive principle requires, then what will be the position? Either there would be a violation of the Constitution on the part of the government, that it has failed to do what the Constitution requires, but from the practical point of view it is impossible for the government to do that. Therefore, the law also should not be taken to a level which is impractical. You may say that the state will ensure or will try to ensure, but that does not mean that it has to do it immediately. That is the way, for example, most of the directive principles are written in that way. The state shall endeavor, the state is enjoined to do this, to do that. Now it is in this way, at least, it is a reminder, time and again, to the lawmakers, to the society in general, that there is an obligation which you have to discharge at some point of time, and therefore you have to work in that direction, because that is a constitutional mandate. But the mandate does not say specifically that it has to be done today. In some matters it may be that you have to do it immediately, but not in all other matters. So some of the types of discriminations the Constitution immediately abolishes and doesn't allow to happen in future also. But some of them it thought it would not be possible. And then if a law which can be enforced and a law which cannot be enforced, then that distinction as to what is law and what is not law, that distinction goes. And therefore, it is also important that dignity of law has to be maintained. And that is one point which has to be kept in mind. So it is for the constitution makers that how much can be done. Now, for example, abolition of untouchability. At least our resolve that even if untouchability has existed from time immemorial, we consider it so bad that it should not continue anymore. And therefore, we declare that the practice of untouchability is abolished. Any exercise of it will be punishable by law. It does not mean that untouchability has ceased to exist immediately, but it is at least a declaration of a determination to abolish it, and then law has been made in pursuance of it to see that it is abolished. It may have not abolished even until today, in the sense that it may still be prevailing in the society, but at least a determination that it is something which should not exist has been made in the Constitution. While some types of discriminations are clearly prohibited, means state shall not make any discrimination on the basis of race, religion, caste, place of birth, etc. Now, this is very specific, that any decision after 26 January 1950, if it makes a discrimination on the basis of any of these grounds, the discrimination will be unconstitutional, and that cannot be allowed to be done. So if the state makes any kind of that discrimination, that will be invalid, and the state is prohibited from doing that. So this can be the distinction as to what is possible, what is not possible, what is so pernicious that should be stopped immediately, and what is pernicious but will take time to be removed. That has to be provided in a manner giving time to the state or to the society to bring that change. Yes, please. Yes, there is clearly a distinction that so far as public international law is concerned, basically it applies to states. That is, the units for the international law are not individuals but states. And if anywhere, on any point, it is generally said now that on human rights issues, the international law also looks at individuals, then there may be specific issues in the area, but otherwise, so far as the constitutional law is concerned, constitutional law is the law which is addressed to the state but as well as to the individuals, that it gives certain rights to the individuals, and it also provides the structure in which the state will function and the powers and limitations of the state with respect to its own citizens. While in international law, the restrictions are imposed on states as parties, not on individuals.
Sir, my question is that we've moved from the supplementing stage to supplanting of law stage. So we see that the practical example of comparative constitutional law in Indian scenario may be, let's take Article 21. So it is known as the bag of all the laws that we incorporate from foreign judgments and laws. So I feel that the purpose of Article 21 nowadays is being, actually transgressing of judicial activism, rather than it has actually lost its sanctity for what it was actually created. So any issue that is being tackled at an international level, if followed through delegation theory in India and incorporating international forums in India in the municipal law, is actually juggled up into Article 21. So isn't it like actually hyper-exaggerating judicial activism? So that's just your viewpoint on that.
Can you illustrate your point by any example? Then I can be more definite in my answer.
For example, let's say if talking precisely of environmental laws,
yes,
we have Narmada Bachao Andolan
yes,
case, right?
yes.
So what I purviewed is it created a more of environmental fundamentalism. There was more of orthodoxy that actually developed after that. That is development versus the actual progression. So maybe in that, so this is what I feel, this confusion that you can say. Is it a more of a judicial activism in that perspective?
Yeah, Narmada Bachao Andolan, of course, has, or you may say, one example of activism in the area of environmental law. But so far as court is concerned, court did not give them any relief. So what was the supplanting actually? I don't know. The only thing is that environment, of course, is acquiring importance, but it is not supplanting anything that is already in the Constitution. If it is read in Article 21, right to life, of course it is closely related to life. A few days back you may have read in the newspapers then that Delhi was the most polluted town in the world. And we were all advised to remain inside the houses, close our windows and doors, and avoid going outside. Now, if a campaign is made for the purpose of improving environment so that people can breathe, is it a violation or supplanting of Article 21? Yes.
I suppose a more direct supplanting would be like what we are seeing in terms of Article 14 interpretation, where we are replacing the reasonable classification test with the arbitrariness test. As which the arbitrariness test, which is part of your due process.
Yes.
So more than 21, I think the question has, as the court itself has said, that by using substantive due process in the place of reasonable classification, that will be unacceptable to the Supreme Court.
Yeah.
But the decision itself has been hugely criticized. So this is the Rajbala versus State of Haryana decision. The decision has been criticized, but this position of law, of substantive due process coming in this manner to replace equal protection, that I think we would love to hear.
Yes. Very good example again. And this is what we have to actually understand and apply. Article 14, with reference to which the classification test was developed, simply says, state shall not deny equality before law or equal protection of the laws. Now what is equality? The court said equality means equality among equals. And whether it is equality among equals, for that they lay down a test in Anwar Ali Sarkar case or Chiranjit Lal case and subsequent cases. It has been found, however, that this test can be applied arbitrarily. Professor Tripathi again had written long back, soon after these decisions, that the test is wrong test. It has only two wings. It doesn't have a third wing, which is also necessary for the purpose of knowing what is equality and what classification is a fair classification and what classification is not fair classification. And his emphasis was actually that always from the very beginning, classification, in the classification, court had used the word classification must be reasonable classification. And for reasonable classification, these are the two tests. Now if a third test is added to it, that the object also must be reasonable, for which you are doing classification, it is not supplanting of anything. It's only growth in the idea of equality. That is, the understanding with respect, what is supplanted? Article 14 is as it was. There is nothing supplantation of anything. The only thing is that the understanding of the court has improved with respect to the concept of equality. And that concept actually has now changed into a much broader and wider concept of proportionality. Proportionality. That for example, any restrictions, any limitations which have to be put on any right, including the right to equality, they have to be in proportion to the right which the individual is affected about. That is, you cannot impose higher penalties than those which are necessary in the public interest, keeping in mind the interest of that person also. So arbitrarily you cannot do things to an individual, even if it satisfies those two tests laid down in Anwar Ali Sarkar or other cases. You cannot arbitrarily act against a person because there is a requirement within equality of proportionality, that the restrictions must be, or even the object for which the classification is being made, that must be a reasonable object. You cannot, long back, Julius Stone had given an example. He said that suppose scientifically it is proved that the best canvas or background for a good painting is the skin of a young girl. So if you flog a girl of 16 years and remove her skin and then make a painting on it, it would be the world's best painting. And therefore paintings can be made, and for making this kind of paintings, this can be done. Can anybody justify it? Because classification doctrine is satisfied. The 16-year-old girl is clearly differentiated from 15-year or 17-year, and therefore 16 is 16. Then the object is also clear, that a country wants to produce the best painting. Now, would you justify it that it doesn't violate Article 14? What is your answer? Don't you think answer is no? You can't justify it. Why can't you justify it? Because it is something unreasonable. So, again, the question is that from where it came? It comes as our sense of justice improves or increases. Yeah, please. You use it. You use the mic. Please let him say what is he saying.
So what I mean to say is, giving a broader interpretation to the provision is also nothing but supplementing to the provision only.
Yes, so you are supporting me. Huh?
Yes.
Okay, thank you.
Sir, but the distinction between constitutional law and administrative law, like using the arbitrariness test to review primary legislation, how far that is justified, whether it is supposed to be a standard for administrative law?
Yes.
As a standalone test.
Do you think it came first in administrative law, then it came to constitutional law? What do you mean by that? Do you think it developed first in constitutional law and then it came, developed in administrative law and then it came to constitutional law?
So my understanding is that the reasonableness test which was there in Great Britain, since there is the doctrine of parliamentary sovereignty, to primary legislations are immune from attack on any ground. So it was primarily applied to administrative decisions. So from there onwards, India has borrowed it, or whether the origin is United States, the substantive due process standard. So that's still not clear where the arbitrariness test has been evolved. Although the court says that it is the underlying test, even beyond the reasonable classification test.
There is a difference between the reasonableness of an administrative act and reasonableness of a law. Even now, the courts do not say that the reasonableness of law can be examined by the courts. But equality requires reasonableness. And therefore, it is that the classification you make, from the very beginning it has been said, it should be reasonable classification. For reasonable classification, these are the two tests. That is, there must be clear distinction between the two classes. And second, the distinction must have a direct relation with the object to be achieved. What the court has now added is, however, every object cannot be the object to be achieved. The object also must be a reasonable object. And it is that aspect which actually is an evolution. Now, so far as reasonableness of administrative act is concerned, it is reasonableness of a particular act with respect to a particular person in a particular situation. Now, the interpretation of constitutional law, of course, a principle is there in, and you may say that the principle of administrative law is being brought into constitutional law, but still the scope remains different. The administrative law is applied only, as you rightly say, to administrative action. The specific administrative action, whether it is reasonable or not. But with respect to legislation or with respect to constitution, it's not simply an administrative action. It is also a question of laws or general laws, whether they are reasonable or not. In administrative law, it is read, reasonableness is read in the law, that law requires. Now here the constitution requires, so there is nothing wrong even if it has been taken from the administrative law, that constitution is also law. So just as law requires that the action of the administration must be reasonable, similarly constitution may require that the action of the legislature should also be reasonable.
Sir?
Yes.
I have two questions.
Yes.
Question number one is, do we have any theories leading upon to
Any-
comparative law?
any-
Theories for comparative law. And my
Any
question-
theories?
Yeah, theories leading to
Any theories for?
comparative law.
Yeah.
And my second question is, do you have any methodology that leads to comparative law, to do comparative law?
Yeah, that you can read in Heschel, and also earlier actually, so far as Guttridge was concerned, Guttridge had actually dealt with these issues as to how to do comparative law. On all books relating to comparative law, the methods of doing comparison are given, and generally it is said that comparables can be compared, incomparables cannot be compared. So actually there has to be something to be compared with, that there is something comparable. And if the two situations are so different that they are world apart, comparison actually is misplaced. So you have to start comparisons not between the same things but similar things, then only it will be. Of course you may pick up ideas from somewhere, but then those ideas have to be seen in the context of the entirety, not simply in the one that here is a good idea, why should I not pick up this idea, or here is a good article or good law provision, statutory provision, that it should be picked up from here and applied. So therefore, so far as the method is concerned, the details as to how to be worked out, whether you will use the empirical method or you will use the theoretical or method, that is another issue which will depend upon the kind of study that you are doing. What is your second question?
Theories leading to comparative.
Any theories? You may call them theories, that, but there is no established theory of comparative law. The comparative law itself may have become a theory in course of time, but there are no established theories of comparative law. The only discussion that has been around is whether comparative law is a discipline in itself or it is only a method of doing something. Slowly it has become a discipline in itself. Initially it was only a method of doing comparison, but now it is acquiring the character of a discipline in itself, that through comparisons we develop some independent principles. And those principles, like for example, the theory of proportionality was developed initially in France and also in Germany. But it is becoming now universal principle. Almost everywhere in the civilized world, that principle is being used. Our Supreme Court more and more relying on principle of proportionality. Although remember that first time with respect to reasonableness in Article 19, in Chintaman Rao case, 1952, the Supreme Court applied the proportionality theory. So it's not that it is for the first time that we are talking of it now, but of course that idea was developed first in France and German constitutions. And in Germany it applies even to invalidate the laws of legislature. That is, the theory of proportionality is so important that laws may be declared unconstitutional if they impose unreasonable restrictions on an individual. And that is becoming now the norm, not so much under Article 21, but definitely under Article 14.
Sir, my question is, it is a settled principle that the provisions of the Constitution cannot be seen into compartments.
Yes.
Because law is dynamic and it cannot be static. And as far as Constitution is a living document. So whenever any situation arose in front of the judges while delivering the judgment, that they are bound to see the provisions into watertight compartments. So at that stage, is it possible to resolve this issue by using this comparative law as a part of public law? If we take example of the case of Novartis AG versus Union of India, the judgment delivered by Justice Aftab Alam in 2013, where indirectly the Honorable Justice twicely said that right to health is not a fundamental right, but it is an extended version of the fundamental right. The same it is with right to privacy, that these rights are not the direct rights, these are the extended version, extended form. So in this situation we can see that they are bound to give decisions by taking the view of the provisions of these watertight compartments. So at this stage, is it possible to solve this the issue by using comparative law?
I have not read that decision very closely, frankly telling you, because I don't have enough interest in intellectual property law, because according to me it is not property of anyone. So and therefore I don't know exactly the details, but so far as your general observation is concerned, that constitutional provisions are not written in a very watertight manner, and they are basically, actually, they are considered to be principles. And principles are capable of evolution. They are not traffic rules. Dworkin drew the distinction between principles and rules, that fundamental rights are principles and traffic rules are rules. There is a difference, that if the red light is there, you have to stop irrespective of what is happening. But so far as principles are concerned, principles are not so definite. There is nothing like a red light kind of situation. Principles can be interpreted much broadly, and therefore there is always a scope for interpretation so far as principles are concerned. And so to that extent, what is life, for example, guaranteed under Article 21, is a matter of principle. It's not simply a matter of rule. What is life means, I think any intelligent person or persons will have different versions of what he or she means by life. And so this difference of opinion, how it arises? It arises because of this, but so far as traffic rules are concerned, there is no scope for difference of opinion. You have to just give it one meaning and nothing more. Yeah.
Which decision, according to you, represents the correct statement of constitutional law? Which of the following decisions, like Malpe Vishwanath, Madia Chemicals, and Rajpala, with regard to arbitrariness test and Article 14.
भाई मैं समझा नहीं तुम बगैर इसके बोलो जोर से हाँ हाँ I don't know all the three cases. So, you give me the citation, I'll read them and send the reply to you.
Excuse me, sir.
Yes.
I have one question to ask.
Yes.
It's related to a judicial activism.
Where are you?
Sir,
Okay.
don't you think in present scenario,
Yes.
sometimes courts actually use judicial activism to violate the legislative action to enact laws?
Yeah.
For example, in Keshwananda Bharti case, court itself says the basic structure is not being defined anywhere. Court will define from time to time depending upon the situation.
Yes.
So, don't you think it's actually restricting the legislating authority to legislate the particular act or a provision? Because they come up with new provision, later it will turn by a Supreme Court saying that it's against the basic structure. Right? So, it's restricting, don't you feel it is, today's in judicial activism actually is restricting the legislative action, legislative rights to enact laws? Court doing it?
Yes. If you construct a house, those engineers or architects who drew the map and who constructed it, they knew at that point of time what are the things, if they are not maintained as such, this house will collapse. But 100 years afterwards, the house appears to be collapsing from somewhere. It is not the same architect and the same engineer who will be brought to tell that what is the remedy to protect it from collapsing. You have to have new engineers and new architects to give us the right advice, what can save it from collapsing. And it is something like that, what is basic structure cannot be determined on the basis of 26 November 1949. I think by and large you will have to say it has to be determined on that basis, but after 50 years, 60 years, 100 years, things may have changed much, and therefore those situations would arise that you may have to know from time to time what is so important that if it is removed from this constitution or changed, the constitution will collapse, or something which is so important for the constitution that will cease to exist. Yes?
I believe it is precisely for this reason that ordinary legislations are not subject to the basic structure. As the court observed in Indira Gandhi case, that basic structure and exercise is important. So ordinary legislations are therefore immune from attack on the law of basic structure. They are only attacking the lack of legislative competence and violation of fundamental.
That is your understanding, but Justice Kher is changing that understanding. In more than one case he has said that it applies to legislation also. And Dieter Conrad also said it should apply to legislation also. So maybe position.
The argument that the legislation is playing a broader from the constitution by bringing the exist of the directive.
I think you have a question and answer. We can't get an argument. We have a different answer. We should give it.
But you can come from time to time to Delhi. You live, then it is easy for you. Whenever you have any problem, you can give me a call or write an email. you will get a response. Yes, please.
सर मैं आपसे क्वेश्चन पूछना चाहूँगा उससे पहले सर फर्स्ट ऑफ ऑल थैंक्स टू दिस इंस्टीट्यूशन फॉर गिविंग मी अ गोल्डन अपॉर्चुनिटी टू जॉइन दिस वर्कशॉप एंड सर मैं जोधपुर से आया हूँ राजस्थान से आपसे सर सवाल पूछना चाहूँगा आर्टिकल 21 का अभी आपने नाम लिया था सर जीवन के अधिकार में मृत्यु का अधिकार सम्मिलित है या नहीं है ये एक बहुत ही बड़ा विवादास्पद रहा है इसमें कुछ लीडिंग केस भी है सर रतिराम और ज्ञान कौर एंड आफ्टर सर राजस्थान में अभी एक रिसेंटली हुआ था संथारा प्रथा तो इसमें सर एक्टिव यूथनेशिया पैसिव यूथनेशिया और फॉर्म ऑफ यूथनेशिया तो इसको सर थोड़ा सा आप डिस्क्राइब करेंगे
He is asking about the claim which people make right to die. One may say that the right to live also includes the right to die. So if Article 21 gives right to life, it also includes right to end your life. When this Ratinam case was decided by the Supreme Court, I criticized it, that a right must be right. Something which is fundamentally wrong cannot be a right. And Supreme Court very soon overruled that decision in Gyan Kaur case. So far, our courts have not decided in any case that one has a right under Article 21 or any other provision of the Constitution to take one's life. Therefore, if the Rajasthan High Court has decided that practice which the Jains follow is contrary to the contrary to the law as given in the IPC, that may be correct. So far as euthanasia thing is concerned, euthanasia is not a fundamental right in Article 21 or 21. You have to create a law for that purpose. And the countries where euthanasia is given, which have made these laws, you cannot imagine the kind of medical facilities they have. You do not have doctors to prevent you from dying. You are wanting doctors to let you die. Means where are the doctors to save your life in this country? And now you want that there must also be doctors to kill people. That a demand which looks totally obnoxious so far as this society is concerned. It is a very expensive business to give right to die to people, which this country can't afford, at this moment at least. So never go by what is happening in some other country when you are studying comparative public law on everything. You have to be careful about what can be adopted, what cannot be adopted, what is worth learning, what is not worth learning. So I think this is time now. Is it? Okay. Okay then. Thank you.